A federal judge declares Tennessee's anti-drag law is unconstitutional. A federal judge says Tennessee's first-in-the-nation law designed to place strict limits on drag shows is unconstitutional. The law is both unconstitutionally vague and substantially overbroad and encouraged discriminatory enforcement, according to the ruling late Friday afternoon by the U.S. District Judge Thomas Parker, who was appointed by former President Donald Trump. The law would have banned adult cabaret performances from public property or anywhere minors might be present. Performers who broke the law risk being charged with a misdemeanor or a felony for a repeat offense. Senate Majority Leader Jack Johnson, a Republican who was one of the law's main sponsors, said he was disappointed with the ruling. Initially, the complaint listed Republican Governor Bill Lee, Attorney General Jonathan Skrmetti, and Shelby County District Attorney General Stephen Mulroy as defendants. But the plaintiffs later agreed to dismiss the governor and the top legal chief, although Skrmetti continues to represent Mulroy for the case. The governor quickly signed off on the statute, and it was set to take effect on April 1st. However, to date, the law has never been enforced because of the federal judge had sided with the group that challenged the statute in March, and he temporarily blocked the law.
Good for him.
The news is amazingly good. Now, let's, as they say, don't count our chickens before they hatch. But there are many, if you read the tea leaves, you can read some things in these tea leaves. The judge focuses not on the fact of whether it's enforceable in drag. And in fact, one of the interpretations of the law will be that will be a case to come on whether you can enforce the imaging of drag appearance as a constitutional First Amendment right. His focus is that the law is so poorly written, which is very important because it is talking about it being overbroad and vague. Now the reason, and yes it is, and in challenges, we've talked about this repeatedly, it's really hard to imagine that the Supreme Court is not going to sustain this federal judge and the appeals that are going to take place because of what the judge rules on. The other good news here is this is exactly what's going to happen to Florida, because the Hamburger Mary's case is now setting the precedent of the exact same thing, how it affects them in their enforcement of the law or following the law being overly broad and too vague, which is exactly what it is. So they haven't gotten into the issues of your constitutional right to be a drag queen and represented in the general public, but the technical implementation of the law. But it may be enough where the House of Cards, one of the big cards has been pulled away, and everything is going to collapse.
And for Tennessee to start this conversation, right? Like, of all states, you know, I mean, for Tennessee to be at the forefront and say, regardless, right is right, wrong is wrong, and this is the law. You know, that's huge for, I mean, that's a big win for us. But like you said, don't get too excited. Don't get too excited. But I'm excited to see that, you know, that there was a judge who stood up, even though he knew who he was appointed by, and said, we're not there yet. And I don't think we're ever going to be there. You know, they came after municipalities and what we were allowed to do as far as having pride parades, and the reach is it's a broad net that they're casting right now.
And trying to make you fearful.
For
how this was written now, me as a woman, if I dressed like Elvis and then just started shaking my little
I would
hips,
love to see that.
I know you would that be considered wrong?
Well, I think broadly, the answer is nobody knows what the answer is, because that's the interpretation of genital representation. It could be it could be genital representation either way, and it just depends on who wants to enforce what. Is the answer to your question.
You know, in the 1950s, Miami and Miami Beach had outlawed what was then known as female impersonations. Like that is essentially what we would think of today as drag queens or something similar. And until like 1954, all the laws pertained to female impersonations. So a lot of female dancers and some queer, some not, they kind of poked fun of the law, and they would show up on stage dressed up as men being like, because the law was so sexist that it like essentially forgot that women, right, could also transgress too.
Yeah.
And then by 1954, they added male impersonation into the law. So one of the things I'm like suggesting here is that it's a federal judge, right, who made this ruling, and Florida's law is equally ambiguous. It's framed in a way that doesn't even mention drag, right? It's about adult entertainment, which could
lascivious by community standards.
I mean, what on earth does that mean, or what does it not mean? But also, one of the things that I want to just put a little nail is that it could also, this ruling, lead to more precise laws written into the future, right? That is like, if the problem is the ambiguity of the law, they can be more precise. That too would not stand the challenge. I think it's really unlikely, because you can't legislate against being a drag queen, right? Like, I mean, how do you legislate against someone?
Which is really just an art form, and it's entertainment.
Of course. It could be a lot of things.
Well,
right?
and yet if you look at Hooters or Twin Peaks, how is that not?
Right, lascivious or whatever.
Well, they call it sexual entertainment,
That
right?
is, according to me, that's sexual.
According to Jack Johnson, like where he said, victory for those who support exposing children to sexual entertainment.
Yeah.
That is what they call drag.
But yet you can take your 5-year-old to Hooters,
and they'll put balloons in his shirt,
and that's
like
completely
parade him
acceptable.
around, and that's okay.
We don't want to get too ahead of this. This is why I suggest about reading the tea leaves. But I think all three of you hit the bullseye, because what the bullseye here is, this federal judge is saying this is overly broad and is too vague to be enforceable, so therefore is unconstitutional.
Right.
If they do, as Julio suggests, okay, well, write the law very specifically. They didn't do that in the first place because they don't want the secondary challenge to come, which is that you can't legislate a drag queen, either in male or female presenting.
They understand the problem.
They understand what the problem is.
They knew what they were doing.
They knew exactly what they were doing.
Which is why they cast that net so far and wide. Let's see what sticks. Let's see what's
and at least it would stick for a while, right? Like that is like enough for election day or enough for whatever, right? There's an end game here.
The other very encouraging thing to that point is Tennessee has never been able to launch the law.
Right.
We don't know in Florida yet if Florida is going to be able to launch the law, because what happened to the Hyatt Regency and to our house in Orlando Philharmonic will be fundamentally affected by what Hamburger Mary's has done to provide the federal challenge. They skipped over the state courts to go directly to federal court and say, please place a stay on this, like what they did in Tennessee. And there's very good indication that that's what a federal judge is going to do. So this is really good news. Just don't count your chickens before.
Don't throw the party yet.
Right. We are Queer News Tonight, the world's first and only live daily LGBTQ+ evening news show from Happening Out Television Network. In the model of PBS and NPR, we educate, inform, and entertain by supporting the 10 pillars of the LGBTQ+ community, with more than 100,000 a week watching on Roku, Apple Television, and other channels. To keep the stories going, we accept donations with 100% transparency. Stay updated and live authentically with Queer News Tonight.